and digital identity governance. The competition is growing, with this year going regional, particularly in the East African region, where participation is being drawn from all the traditional East African countries, that is Uganda, Kenya, Tanzania, and Rwanda. The competition will comprise of national rounds that will be held in each respective country. The national rounds will entail preliminary rounds and quarterfinals. These will all be held on one day. In the morning, you will have the preliminary rounds, and in the afternoon, you will have the quarterfinals. The national rounds will kick off with Kenya on the 11th of September. And these will be held at the University at River, followed by the national rounds on 15th, which will be hosted at, those for Rwanda will be on the 18th of September, which will be hosted at Kigali Independent University. And finally, we will crown this stage of rounds with those of Tanzania on 22nd September at the University of Dar es Salaam. To qualify for the national rounds, the top 4 marks in the memorials in each country will be picked, and those will move to the national rounds. From each of these rounds, only one team will move to the next round. So please take note, top 4 marks from the memorials in each country. And thereafter, following the conclusion of the preliminary rounds and the quarterfinals, we will have only one team that will proceed to the next round, which will be semifinals and the grand finale on the 25th of September that will be held at the University of Dar es Salaam. We will start off on that day, on 25th, with semifinals in the morning, and the grand finale will be in the afternoon. Obviously, the competition has goodies in terms of being that it's a competition for those who will win. We have different categories of awards. So rest yourself to compete and be able to fall in one of these categories. So we have the overall champion who will get a trophy, the overall trophy, and a cash prize of 1,500 USDs, plus an all expense paid trip to attend the 7th Privacy Symposium Africa that will be taking place in Nigeria. The first runner-up will receive a trophy and a cash prize of 500 USDs plus a certificate. We have the category of best oralist, and the best oralist will receive an accolade and a certificate. And the last category will be best written submissions, either as an applicant or respondent. And each one of these categories will receive an accolade and certificates. Ladies and gentlemen, so brace yourself. The competition is stiff, big, stiff, and we welcome you to prepare adequately. In terms of housekeeping rules for our bootcamp, we will have a Q&A at the end of every, at least the last 5 minutes of every presentation that will be made. We will have a Q&A, but we would like you to write your questions in the chat. Utilize the chat. Go into the chat room and send your questions. We will definitely have them addressed. Also, please don't forget to use your unique identifier number in the event that you need to identify yourself for something. Please do that. Even in the chat room, actually, you could quote your unique identifier number and then the question. That will be good. With this, I wish to welcome our Executive Director of Unwanted Witness to officially grace this bootcamp and open it up. Miss Dorothy Mukasa, you're most welcome to make your remarks.
Thank you so much, Frida. Good afternoon, esteemed participants, legal scholars, privacy advocates, and future champions of digital rights from across East Africa. It is with immense pride and excitement that I welcome you to the 2025 Unwanted Witness Regional Privacy Moot Court Competition. Today we are holding these bootcamps taking place starting today until the 15th of May, 2025. These bootcamps mark a critical step in preparing the Mooters for the 4th edition of our regional competition, a platform that has grown since 2022 into a beacon of advancing privacy and data protection in Africa. Over the next 3 days, we will focus on equipping you with the knowledge and skills to excel in the competition as follows. Today, May 13th, we will be introducing you to privacy and data protection, laying the foundation for understanding the legal frameworks and principles at stake. Then tomorrow, 14th of May, we will tackle written memorials, guiding you to craft compelling, well-researched submissions that reflect rigorous legal analysis. Finally, on the 15th, we'll dive into oral memorials, honing your advocacy skills to argue persuasively before the panel of distinguished judges. These sessions, led by experienced legal practitioners and privacy experts, are designed to empower you to tackle the complex issues presented in this year's hypothetical case. Ladies and gentlemen, this year's theme, safeguarding personal data in national ID systems, is both timely and critical. As East African nations embrace digital identity systems to enhance governance and service delivery, we face pressing challenges such as privacy breaches, data misuse, and exclusion of vulnerable populations. The hypothetical questions, therefore, Uhuru Farango and the Republic of Azmia challenges you to navigate the tension between state objectives, such as the national security and inclusivity, and the fundamental right to privacy as enshrined in the various domestic laws, East African Community Treaty, and international frameworks. Your role is to dissect these issues, propose innovative legal solutions, and advocate for a future where the technology upholds human rights rather than undermining them. Since its inception, the Unwanted Witness Privacy Moot Court Competition has been more than a contest. It is a movement to nurture the next generation of legal professionals who will defend digital rights across Africa. By engaging with real-world scenarios, you will deepen your understanding of data protection laws, refine your advocacy skills, and contribute to shaping a digitally inclusive and rights-based future. This year's regional expansion to include 4 universities from the East African countries underscores our commitment to fostering cross-border collaboration and legal excellence. As participants, we expect you to approach these boot camps with curiosity, diligence, and integrity. Engage actively with the sessions, learn from your peers, and draw on the expertise of our facilitators. As you prepare to argue for both the applicant and respondent, embrace the challenge of exploring diverse perspectives. This exercise will sharpen your ability to craft balanced, persuasive arguments grounded in law and principle. Remember that your efforts here are not just about winning awards. Your work is about learning, growing, advocating for justice in an increasingly digital world. At Unwanted Witness, our mission is to advance digital rights through advocacy, research, and education. We believe that privacy is a cornerstone of democracy and human dignity. This competition, now in its fourth year, reflects our unwavering commitment to empowering young legal minds to address the challenges of the digital age, from biometric data collection to surveillance and beyond. At this moment, I would like to appreciate our various partners, both in national, regional, and international, for making this competition possible. Now, ladies and gentlemen, as we embark on this journey, know that you are part of a larger fight for a world where technology serves humanity without compromising our rights. Let these boot camps ignite your passion for privacy law and inspire you to become advocates who will shape policies, protect individuals, and uphold justice. I wish, therefore, to wish you all the best in these transformative sessions and look forward to witnessing your brilliancy in the competition ahead. Thank you so much, ladies and gentlemen, and let's get started.
Thank you, our dear Executive Director. At this juncture, I would like to invite my co-facilitator, Ms. Edna Kasozi, to say one or two words to our esteemed participants, and thereafter we would also hear a brief, in two minutes also, we will hear from our representative from Civil Rights Defenders, Ms. Apollo. Ms. Edna, you're most welcome.
Thank you so much. Good afternoon, everyone. My name is Edna Kasozi. I work with the Personal Data Protection Office in charge of licensing and legal affairs. The Personal Data Protection Office is an independent department under the National IT Authority. We know the government of Uganda decided to digitize the economy, and that inevitably had to create room for a national regulator in that space. And that is how the Personal Data Protection Office comes into existence. It comes into existence because with digitization of our economy, you realize that for every decision you make, you have to involve personal data as one of the common denominators or many of the factors for you to make an informed decision. So Personal Data Protection Office comes into existence to guide and regulate the collection, the processing, and the control of personal data. We all know that today, personal data is the new oil. It is very valuable and it has no boundaries. But we also need to appreciate that it's not something that just happened yesterday. Personal data and personal data protection existed even before our forefathers were thought of. So today, in this exercise, we are going to appreciate how personal data is appreciated in all spheres of, our lives. Like in this concept, in our digital economy, which is growing very fast. How is personal data protected? How is it factored into the technological advancement in our culture, in our homes? We do have rights, we do have obligations on so many spheres. So as we go about life, and there's so many dynamics about life, personal data has obligations, and each and every one of us as a data subject has rights. So how do we uphold those rights? Do our laws appreciate? Because remember, once upon a time, we were in the analog. So do the analog laws, the laws that existed before we held this smartphone, started having a virtual meeting, do those laws recognize and appreciate personal data? Do they protect the sanctity, the integrity of personal data? So we're going to try and appreciate it at that level. What regulations do appreciate personal data? Do they appreciate it in harmony? Do they appreciate it on an individual basis? That is what we are going to explore, both at a domestic level, like maybe in Africa, then internationally, the people who appreciated it way before us. How did they go about it? So we're going to have like a picture of comparison to see how personal data is appreciated in all spheres of our lives, especially in this digital era. Thank you so much.
Thank you, Edna, for those words. They are really flagging us, and we can't wait to hear the different thoughts as we.
You're welcome.
Ruth? Miss Ruth?
Can you hear me? Hello?
We hear you loud and clear, Ruth. You can proceed.
Right. Thank you. So, Ruth Apollotti is my name. I work for civil rights defenders, based in Stockholm, in Sweden. So, we work to defend and promote human rights in Africa, in Latin America, in Asia, and some parts of Eastern Europe, covering areas of accountability, capacity building, security, and enhancing engagement of various stakeholders in this region. So for this particular project that we are partially funding to the unwanted witness, we are trying to strengthen the aspect of strengthening stakeholder engagement in the aspects of privacy. That is the areas of empowering young scholars at the university level. That's why we see the bootcamp and Moot competitions. So I'm basically here to just witness, not do any M&E, but just to see the good work and the deliberations that the unwanted witness is performing, and looking forward to the rest of the steps that are planned ahead. Thank you, and looking forward to the session.
Thank you, Ruth. And we once again appreciate the support.
You're welcome.
So, ladies and gentlemen, without wasting time, I would like us to start. Already the executive director informed you that basically the bootcamp for today is to introduce you, make you understand, give you an understanding as to what privacy and data protection is all about, at least the fundamentals. And there's no other way other than to start off by trying to understand what does privacy mean for you. I would like you to use your chat and attempt to tell us what does privacy mean for you. And we will sample some of your responses so that we can move forward in about 3 minutes.
Sorry, I kind of lost you there. I didn't hear this very well. Could you please repeat for me? Thank you. Yes, you're speaking to Edna, but I think I lost you a bit.
Okay, so
And I
Edna, we are starting off with the first module, which is understanding privacy. And the participants, our mooting teams, are going to attempt to tell us what privacy means for them as at an individual level. What does privacy mean for them? And we would like them to use the chat room to give their responses, and we shall sample some of these responses and read them out before we can continue in the next 2 minutes, because I had given 3. So in the next 2 minutes. And while you're at that, kindly let's have our mics muted so that we don't have feedback during the proceedings. Thank you. Keep those responses coming in. I'm going to read them as they come in. And at least if we can attain at least 5, and then we will be able to move, just to get a sense of what privacy means for all of us. So I have from Ruth, freedom from prying eyes, accessing privately, identifying information from holders. Okay, we have it means to be able to control access to my personal information. My personal information, communications, it is also just being able to decide what to share and with whom. We have someone saying the state of being seclude from the presence and knowledge of others. The right of individuals, organizations to control access to their personal information, data and activities involves protecting sensitive details from unauthorized use, disclosure, and exploitation. A right to have control on personal information and keep it confidential. A state where one is not being observed, disturbed by other people. A state of protection from public attention and access. Okay, I'm going to leave it to that. Privacy is the ability to protect personal information. So keep them coming. We will catch up with them as we proceed. So to continue our reflections on what privacy is, historically, privacy has been defined as the right to be let alone, emphasizing freedom from external interference. And this was expounded further by Alan Westin, and to include the ability of individuals to control access to their personal information, body, communications, and space. And some of these things, I have seen them in the responses that you have made in terms of what privacy means for some of you. In practice, privacy means deciding who knows what about you, when, and how, whether it is your location, whether it is health records or online activity, name it. And already this has been also alluded to in some of the responses. But let's also get perspectives historically, where privacy began. In the ancient times, privacy was tied to physical spaces, like sacred temples in Greek and Roman societies, where access was restricted to protect the sanctity. But as time went by, between the 17th and 18th century, we had philosophers like John Locke, who introduced ideas of self-ownership, laying the groundwork for privacy as an individual right tied to personal autonomy. And in 1890, we had others who say that the right to privacy is in response to the invasive journalism enabled by new technologies like portable cameras, and argued that legal protections against, and urged for legal protections against unwarranted intrusions. So this was advanced by Samuel Warren and Louis Brandeis. And then when we moved to the 20th century, we had privacy gaining global recognition as a human right. And when we look at the Universal Declaration of Human Rights, the UDHR, in Article 12, it states that no one shall be subjected to arbitrary interference with his privacy or her privacy, family, home, or correspondence. Today, privacy is challenged by digital surveillance, social media, artificial intelligence, requiring new frameworks to protect individuals. Privacy is not something that I am merely entitled to, but it's an absolute prerequisite. This was something that was advanced by Marlon Brando. And with this, we see that privacy has a role as a foundation for personal freedoms, dignity, without which we as individuals, you and I, would lose control over our lives. With this, I would like us to also look at the types of privacy. Already in your submissions, I could see a bit of mentioning of these, especially when some of you talked about communication. So we have communication privacy, we have bodily privacy. So bodily privacy, when we speak bodily privacy, we simply refer to the control one has on their physical body, medical decisions, and we can, for example, see laws that protect against forced medical procedures or non-consensual experiments, where obviously informed consent is needed, especially in health care. So bodily privacy ensures autonomy over one's physical self, critical in debates over reproductive rights or medical ethics. While communication privacy involves the security and confidentiality of personal communication, such as letters, phone calls, emails, texts, name them. Example of those, the end-to-end encryption in applications like Signal. Signal protects messages from interception by third parties, including governments or even just mere hackers. Without communication privacy, individuals risk surveillance, which can have chilling, which can chill free speech or expose sensitive information. We also have territorial privacy that concerns control over personal spaces such as homes, vehicles, workplaces. And usually in this, we have legal protections against unauthorized entry, where you see labels on either premises or even actual homes, trespassing, don't trespass, you're not allowed to trespass. Or others have gone as far as having hidden cameras in these private spaces, not only at workplaces, but we've seen an uptick of hidden cameras as well in homes. This type of privacy is very important because it safeguards physical boundaries, ensuring a safe space for personal life and expression. Then we also have information privacy, which focuses on control over personal data such as names, addresses, financial details, or online behavior. Such privacy requires a user's consent before apps collect, for example, your location data or share it with advertisers and any other personal details. And it is critical that in this digital age, that information privacy is treated as very crucial especially in relation to data breaches or misuse, and where such happens, it can lead to identity thefts, discrimination, or exploitation. Sorry. Are you able to see my screen?
No, we can't, or I can't.
You can't, okay. Let me see. So you're able to see it?
Yes.
Yes.
And just, yeah, get some yeses, then we can move on.
Yeah, we can see it.
Can see it.
Okay. You can see it. Okay, all right. Okay, okay, good. So we've seen the text of privacy, and we've also had privacy. So I'd like us to move to what data protection means. Okay, so I want us to talk about what data protection is all about. Data protection involves the legal, technical, and ethical measures to ensure personal data is collected, processed, stored, and shared securely and responsibly. It focuses on safeguarding personal data defined as any information relating to an unidentified or identifiable individual. Maybe, for example, your name, your email, your IP address, name it. I want us to delve into the significance of data protection in this digital era. Okay? Why is it important for us to address our minds to data protection? One of the things is obviously relates to the explosion of data. For example, when you look at today, the world generates 2.5 quintillion bytes of data daily, driven by smartphones, Internet of Things devices, and online platforms. The other bit why we need to address our minds to data protection is the risks, the rising risks that we keep interfacing with in form of data breaches that expose sensitive information. For example, in 2017, Equifax breach compromised personal data of about 147 million people, leading to identity theft and financial losses. The other aspect is in relation to eroding trust. Surveys have showed that 64% of consumers are concerned about how companies handle their data, with many feeling powerless to protect themselves. Also, the economic stakes, the impact on the economy. Data today is being considered as something that fuels most of the industries, especially in relation to advertising, e-commerce, artificial intelligence, contributing trillions to global GDP. However, misuse can lead to hefty fines. We will see a bit of these fines and how they are provided for in our different national laws, but also the impact on society. Data protection ensures fairness, preventing exploitation through practices like predatory targeting or discriminatory algorithms. I want to share a quote that says, that relates to, that helps also to amplify why it should be our business to understand data protection and why it is important. And Clive Hamby says, data is the new oil, but without protection, it's a liability. And with this quote, it highlights data's value as a resource, but you see it emphasizes that without safeguarding this data, especially the personal data, it could harm individuals and organizations. With this, I would like us to look at what the role of personal data is in modern societies. Already we have alluded to the fact that it is a key driver of many economies, and our economies as East African countries, we are not an exception. Personal data empowers targeted advertising. And if you look at some of our economies, for example, Kenya, Safaricom uses customer data to deliver targeted mobile money ads, driving financial inclusion and revenue. But on the whole, in terms of the economy, you can see that advertising, targeted advertising, is boosting SMEs' revenue by diversifying markets and enhancing consumer engagement, which is contributing to 5.1% of East Africa's GDP growth, and that was in 2023. In e-commerce, it has enhanced SME productivity and market access, contributing to job creation and economic resilience. And for this in East Africa, it has led to 2% of GDP growth in 2022. An example globally, if we are to go globally, advertising, targeted advertising is contributing to 4.2 trillion US dollars, and that was as of 2023. So you can see how it is influencing economies, but it is also a social enabler. With this data, it enhances user experiences through personalization. We've seen the uptake when it comes, for example, to Netflix and its recommended algorithms, Spotify, curated playlists, name it. For example, when you're streaming, the streaming platforms they help to analyze viewership, listenership, the habits, and they help to suggest content. And at the end of the day, we see user satisfaction. This data has also been very important to government functioning. We see that data supports public services like health care systems, electronic health records, or national statistics in the form of, for example, census data that informs policy planning. For example, contact tracing apps during pandemics relied a lot on or rely a lot on location data to manage public health. I think we interfaced with a bit of this during COVID. And then also data has contributed to scientific progress. Aggregated data fuels research from medical studies to planning. For example, anonymized health data helps researchers develop treatments for diseases. Like cancer, this was a case when we both was confronted with COVID. This case, but also with this data, the raising use of this data are risks handling. Okay, so in the form of surveillance, where governments or freedoms, profile, algorithms, unfair people leading to this. For example, by to they went off. Do you hear me? Do you hear me? Can I just get a show of hands?
Yes, we hear you.
Do you hear me?
Yes, we do.
Yes, we can.
Yes, I do.
You hear me?
Yes, we do.
Okay, I'm experiencing a bit of internet
Yeah,
connectivity. Yeah.
yeah,
Okay.
interruptions, like
let me
you
try
keep.
to log off and get on back. What? Apologies, please. My internet connectivity is failing me, but I'm back now. Let me just. So we were looking at the role of personal data in modern societies, and we were looking at particularly the aspect of the risks involved in handling this data. And I wanted to share, we were at that point where we were looking at instances where, as a result of mishandling, fines have been incurred. And one example I would like to give, the nature of our data protection acts or laws at our national level, we have been in the form of administrative fines, others are criminal fines for non-compliance. For example, in 2023, a school was fined in Kenya 4,550,000 Kenyan shillings for posting a minor's images without the consent of the parent. And a digital credit provider was also fined 2,975,000 Kenyan shillings for using third-party contact data without consent. Obviously, highlighting the fact that just give me a second. Highlighting the fact that there is need for data to be used responsibly. And I have several examples. We also see from neighboring Tanzania in individual fines ranging from 100,000, which is 100,000 Tanzania shillings, approximately 43 USDs, to 5 million Tanzania shillings, which is an equivalent of 2,200 USDs, with also imprisonment of 5 years or both. In Uganda, we have fines ranging from 4,800,000, approximately 1,300 USDs, and for individuals, for offenses like in regard to unauthorized disclosure. In Rwanda, we have 2 million Rwanda francs, an equivalent of 1,850 USDs, to 5 million Rwanda francs, which is an equivalent of 4,630 USDs. So you can see how mishandling of data has been has been treated, especially where there is non-compliance. So with this, I would like us to quickly move to the principles of data protection. The key principles in data protection, and these are informed or based on what so far we see and observe in our data protection laws. In Kenya, these principles have been amplified in sections 25 and 22 of the Data Protection Act. And in Uganda, we find them in Article 3 and 5 generally, and then for Tanzania in section 6 and 15, and while for Rwanda in Article 37 and 38. And obviously we cannot not also give credence to the global standards that have also informed the formulation of our data protection laws. So some of these principles include lawfulness, fairness, and transparency, requiring data processing to comply with laws and to be fair and clearly communicated when it does happen. Purpose limitation, that should you find yourself that you need to collect data or you need to process it, it should be collected for a specific purpose, and it should be legitimate, and you should not repurpose it. Yeah? And this should not be done without consent. For example, a fitness app cannot share workout information or data with advertisers unless they have explicitly received authorization from the owners of this data, who will be the data subjects. The other principle is data minimization. You only collect that data that is necessary and for the stated purpose. So for example, an online store should not require your birth date for a simple purchase. The principle of accuracy. Data must be corrected. The data that is collected must be correct and updated to avoid harm from errors. We have the principle of storage limitation. Once you collect this data should be obviously used for the purpose that is has been stated, but then it should also not be retained for a long time. So if it's a privacy policy, the retention period should be stated. So you should retain this data for as long as you need it. But once the need elapses, then this data should be disposed of. Integrity and confidentiality. Protect data against unauthorized access, loss, or breaches using measures like encryption and many more. For example, banks use secure protocols to protect financial transactions. And we also have the principles of accountability that involves organizations proving compliance through audits, the privacy policies or notices that are in place, and documentation. For example, if you were to appoint a data protection officer to oversee the implementation or the adherence to the privacy policy of the organization, there should be proper documentation, and there should be, audits that are conducted to take stock of this adherence or compliance. With this, I want to conclude that privacy is a fundamental issue evolving with society and technological changes. Obviously, there have been debates as to whether privacy is really a fundamental right. There have been pockets of debates and scholars who advance that, well, if it's being that it can be waived, that on that basis it should not waived. Obviously, usually it is waived in situations of national security, and these are some of the reasons that have been given for waiving the right to privacy. But as we've seen much earlier, you cannot enjoy any other right if your dignity has been lost. If you feel if your dignity has been lost, you have lowest self-esteem, you feel dehumanized given whatever circumstances, it becomes very difficult. Because, for example, if it's a school and you've been bullied, for example, you will not be able to enjoy your right to education, for instance. So it's it's obviously a thin line, but it is really, privacy is very critical for the enjoyment of the other rights. Data protection is critical going forward in relation to trust, security, and ethical innovation in the digital age. And obviously, it calls upon all of us to advocate for stronger privacy laws and adopt responsible data practices. I want to end with Edward Snowden, who says that the real danger is the gradual erosion of individuals' liberties through the automation of everyday life. So with this, we see that with the increasing use of personal data uptake of personal data, and with less safeguards, possibility of you losing your privacy increases, obviously through the either inadequate safeguards or unchecked data collection, and which calls for obviously vigilance to protect this right and other freedoms. I thank you for listening. At this juncture, I will monitor the chat, but I want to invite Edna to take us in the next modules 3 and 4. You're welcome, Edna.
Thank you very much. Wow, that was quite the submission. There is a lot to learn. So from the Personal Data Protection Office, I'm going to talk about personal data protection from the international perspective. Personal data protection from the international perspective. Data privacy under international law. So I'll be sharing my screen shortly. Just a minute. So there we go. Data privacy under international law. Like I think has been already highlighted by the previous speaker, data privacy and generally data protection is not something that happened yesterday with maybe the evolution of, AI or digitization of our economies. Way before we were thought of, like even before our forefathers, data protection and privacy was in existence to some extent. And I'm going to illustrate how data privacy has evolved. Though my observations indicate that there is a very, I wouldn't call it a very thin line, but very many people confuse data protection with data privacy. So the diagram that is currently displaying, clearly distinguishes between data protection and data privacy. The gentleman that is holding in a dark or a black umbrella is protecting something on their phone. Now you realize that they're just protecting it, but anybody can come and access. You can protect something, but it could be accessible to maybe other users or the audience or the public or whoever. But data privacy, there's that integrity, that sanctity that you want to keep to yourself. And this is what we're going to be focusing on today. So this diagram still goes ahead to emphasize the difference between privacy still and security. So the common denominator is personal, maybe aspects of your life, personal information. Now with privacy, it is your personal information. And if it is personal information, definitely you would like it to be used in a manner that is authorized by yourself, and you value these certain aspects of your life, and it is only accessible on a needs basis. Now, the difference on the other side is confidentiality, security, integrity, and availability. So that's how data can be maybe made secure. But today we're going to focus on data privacy. So, like I said, the evolution of privacy existed way before all of us were thought of. Like if you read history, you realize that there were walls that were separating rooms and different spaces, like in different spheres, like people, the way people used to have meetings. Then fast forward, like 1948, the Universal Declaration of Human Rights. It was very clear and upheld the right to privacy of an individual. So fast forward 1995, now we're talking about Uganda, Article 27 of the Constitution. It is very clear and emphasizes the right to privacy of an individual. We all know this. Then fast forward, that is when our country decided to digitize our economy. There has to be some kind of integrity and some kind of regulation, some kind of, a uniform way of managing, of handling, of dealing with personal data. So we got some sectoral laws into existence. And these are the ones that legalize certain things that are happening right now. These are the laws, the Computer Misuse Act, we all know. This is something that came to protect the privacy of certain individuals because people were misusing technology to undermine people, to harass people. So the Computer Misuse Act came into existence. Then we have the electronic transaction laws and the e-government laws. These are what legalize, these are the laws that legalize the electronic transactions. Right now, there's somebody who's sending mobile money out there. Then there's somebody who, you're doing procurements online. There is so much that is happening. But remember, all these to happen, there's personal data, which ideally is supposed to be kept private, but because certain things need to happen, we need to advance, we need to bring these laws. And they all come into existence because they need to guide the way personal data relates to these things. For electronic transactions to happen, there are certain aspects of your personal life that you want to be kept private, but they have to come into play. Just like the e-government, there are certain private aspects of your life that have to, come into play for these laws to function. Now, between 2019 and 2021, the Data Protection and Privacy Act and the attendant regulations came into existence with the core mandate of enforcing the Data Protection and Privacy Act. Now, this act came into existence to protect the collection, to kind of create some kind of a framework, discipline, integrity in the way personal data is collected, personal data is processed, is stored, is managed, is dealt with, definitely to do so much. So we proceed. Let's look at privacy under international law. The Universal Declaration of Human Rights is one of those oldest frameworks that I think we have all heard about. And it's a foundational document that emphasizes the basic rights to freedom to which all humans, irrespective of your sex, your gender, your physical attributes, are entitled. It's an underogable right. It was adopted by the UN General Assembly, who has responsibility. Civil rights, political rights, economic rights, social rights, and cultural rights. Basically, for somebody to be able to express themselves, to express their civil rights, political opinions, economic rights, your social, what do you think, your cultural rights. And it purpose to promote the basics, you see, peace, dignity. That was after the Second World War. Definitely, we all know what happens when a war falls into comes with war. There is a lot of human rights abuses. They are vulnerable people whose rights are disregarded for one reason or another. So in the aftermath of the Second World War, I think there was really need to uphold the rights of an individual, the privacy of an individual, irrespective of whether you're a child, whether you're an elderly. We all have that right to privacy. One important aspect we need to take home is we've heard that there are some nations in the world that are not bound by this. You see, it's a declaration on human rights, and the declaration may be advisory in nature. This means that it does not bind each and everybody, but what we cannot deny is that it has influenced many constitutions, many domestic laws, and international treaties. There are some spheres, there are some spaces that may not acknowledge, but we should all agree that for somebody to come up with maybe a legal framework, a policy, a best practice guideline related to rights, privacy of individuals, I think they may be in the quest for research and, trying to leverage on so many other maybe literature and studies and theses and so on. This is something that everybody looks at. It may not bind you in its totality, but we need to appreciate that it has influenced very many constitutions, because whoever sat down to come up with this framework, they really did put in the work. And this is work we all appreciate is universal. And we are all human, irrespective of your race, your color. Everybody has that underogable right. So Article 12, like was highlighted earlier, gives the right not to have arbitrary interference with their privacy in their family or home or correspondence, or to attack upon their honor or reputation. This is somebody's personal space. So Article 12 is very clear and emphasizes the right to privacy of an individual. And the right to privacy touches certain aspects of your personal life. your person, your space, your family, your home, your correspondences, your honor, your reputation, your character as an individual. We all know right now that there's a lot of mental health issues that we are dealing with, and most of these things we are dealing with is because we want to look at the world in an artificial way. Social media, AI, they paint a very plastic picture of what life is supposed to be. But when you reason in the abstract, things are actually different. So it is important that everybody, first of all, gets to appreciate that them as an individual, they have rights. But then it is important to acknowledge that these rights are not something that you should buy or should be, what can I say, they should be bought or should be maybe enjoyed in exchange for something. They should be free of charge at all times. Everyone has the right to the protection of the law against such interference or attack. So they are free right from when one is declared a human being. That is the Universal Declaration of Human Rights. So you realize that international law looks at privacy in this manner, and then we'll have to compare this with how other international frameworks appreciate privacy of personal data and certain aspects about our personal lives. So next, we look at the concepts that this declaration focuses on: the protection of privacy for the family, for the home, in your reputation, and those small aspects of your life that touch you as an individual. A requirement of the law to exist and to be enforced to protect individuals from all violations. And this is, I think, a basic which I think all domestic laws are bound to have. Next, we look at the International Covenant on Civil and Political Rights. This is also a framework that forms part of the treaties that contributes to the Universal Declaration of Human Rights. It mirrors the Universal Declaration of Human Rights in so many provisions. If you get to compare the two frameworks, and gives enforcement to Article 12. It came into existence way back, that is 1966, and was adopted by the UN General Assembly. But unlike the Universal Declaration of Human Rights, it binds all the states that have ratified it. So it works in such a way that whoever decides to subscribe, you need to be seen to abide by the provisions under this framework. And the Human Rights Committee is responsible for enforcing the provisions of this framework. And this framework focuses on freedom of speech, the right to fair trial, freedom of religion, protection against torture and arbitrary detention, and electoral rights and participation in public affairs. The basic right to express yourself as an individual is something that this framework explores. Article 17 of this framework states that no one shall be subjected to arbitrary or unlawful interference with their privacy, their family, home, and correspondence, or not unlawful attack on their honor or reputation. Now, to go back a little bit, you realize that this article is similar to Article 12 of the Universal Declaration of Human Rights. Similar in nature, this is 17, the other one is 12, and it mirrors the Universal Declaration of Human Rights. So these are frameworks that work hand in hand to uphold the rights to privacy for each and every individual, irrespective of your gender, your race, your ethnicity, name it. So next we have the African Charter on Human Rights and People's Rights. And sometimes people call this the Banjo Charter. This is also a framework that was adopted by the African Continent, Organization of African Unity. And it also aims to promote and protect human rights and freedoms across the African continent. It came into existence in the mid-80s, and the African Commission on Human Rights is responsible for its enforcement. And such frameworks, the frameworks that I'm talking about, usually the responsible authorities or the responsible bodies that look out for its enforcement usually get very active, usually in times of emergencies like during a pandemic, around a war, when there are floods, when there's an earthquake, because you realize that during such times, like people or like maybe states or domestic law enforcement tend to disregard those basic rights. And because of the confusion at that point, it's hard to maybe enforce the law or maybe seek redress from maybe a certain authority. People's rights are really, you've heard of some countries where because of war, children do not even have the basic right to maybe step out to play, the basic right for somebody to express their civil liberties, their political opinion, to dress the way you want, to speak freely because you have an opinion that you're entitled to. Now, this one focuses on people's rights, and that is self-determination, what you believe in, development, and a healthy environment. It is your right to live a healthy environment. That is where you realize that we have activists that come to demonstrate when, of course, issues such as, toxic maybe material comes into our communities, like maybe certain chemical plants or things like that that may be harmful to people's lives. So it is your right to live a healthy life. This framework goes out and outlines people's individual responsibilities towards the family unit, society, and the state at large. We know that family begins at home, and that saying which goes that if you want to change the world, you go home and love your family and take care of your family. And that is when you begin to maybe make a difference in the world. Charity begins at home. So it outlines the individual responsibilities towards the family unit, because it's from a family unit that we form an extended family, that we form a community, that we form a district, a municipality, a division, and then before it, it's a state. But it does not permit suspension of rights during emergencies, such as war or pandemic. And this one is very key when under this Banjo Charter. Like I said, when we had the COVID pandemic, I don't know about the other states, but in Uganda, you realize that there's that underogable right to consent to have your personal data collected when maybe you want health care or when maybe you're sick and you need medical attention. For a child, an adult or a guardian should consent on their behalf. Now, a situation arises whereby during the pandemic, you realize that the right to consent was at some times disregarded because people said there was a greater good. We needed to maybe do research. We needed to save a life. But this law is very intentional, and it says even in a situation where there is war, even if it's a pandemic, people's rights should be upheld and protected to the farthest extent as much as possible. It does not, this framework does not expressly provide for the right to privacy, but rather implies it. That is why it does not have a specific provision, unlike the two that I previously talked about. It just implies it, but you realize that it upholds the right for somebody to express themselves the way they want without limitations. And that is a right. So with this framework, there's it explains in details the right to privacy, though there is no particular provision. So you realize that there are other laws that it works in harmony with, like the Universal Declaration of Human Rights and the one that I just talked about before. To work in harmony, they go ahead to critically analyze this law, and that is why the two laws, that is Article 12 of the Universal Declaration of Human Rights, and the one that comes after that, that is Article 17, they go ahead to expressly create a provision that upholds the right to privacy. So the right to privacy is emphasized by several articles that protect dignity, liberty, and family life. So after critical analysis of this framework by the regional states that, subscribe to it, national laws have emerged to strengthen privacy protection across Africa in response to the digital age. We need to appreciate that the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights, and this Banjul Charter, they do work in harmony to supplement and support each other. So some of the states that do subscribe to these frameworks include South Africa, Kenya, Nigeria, Ghana, and Uganda. There are so many others that do subscribe and consider provisions under this law. They do subscribe, some are bound by some of these frameworks, and you realize that whatever is not very clearly highlighted in any of these frameworks, when you critically get to analyze the domestic laws of the countries that have highlighted here, they get to shed more light on what is missing on these frameworks. So we need to appreciate that privacy is, at an international level, is appreciated. And it is not something that came into existence yesterday because of the digital age. Even before the digital age, it did exist. You realize that way back, the Declaration of Human Rights. It came into existence before we held the smartphone, before I could have a virtual meeting with you, but you realize that these are things that are still applicable. The provisions, the principles still do apply, even when you want to appreciate it from a digital lens. I hope this is something we all appreciate. So how do we balance privacy and other rights? Because as a person, the right to privacy, the right to education, access to so many other things. So national security versus privacy, I think this is something that is very sensitive, but in so many situations, we, just like the previous speaker said and presented, we have that right to privacy. But what happens in a situation where, in a matter of national security, your privacy as an individual is disregarded? Which one is the greater good? And this is a question that we are throwing out there to debate, for people to critically analyze and see how we can harmonize and be able to see that national security and privacy get to live, to coexist in a community, because security is paramount and likewise privacy is also paramount. National security, that is protection of a nation's sovereignty, its citizens, institutions, its interests against external and internal threats, both internal and external. Now, when you look at privacy, the fundamental rights recognized by international, national laws of individuals to control access to their personal information, thoughts, communication, physical spaces, generally expression. So when you look at it, when you try to define or appreciate national security, privacy in the digital age, does it differ from the way it is defined or appreciated from the analog sense? The right to privacy in the digital age. The right to privacy in the digital age refers to the protection of individuals' personal information, communication, online activities from unlawful surveillance, data misuse, unauthorized access, especially in a world where technology and other internets play central roles in our day-to-day lives. Now, we have to appreciate that at this point, I think post the pandemic, there is no turning back. I don't think we're ever going to go back to that time where if I want to go and pay taxes, I have to walk and go to URA in Nakawa. I don't know whether we are going to ever go back to that point whereby if I want my mother to get money in the village, best case scenario, I know somebody going to the village, then I physically give them the money to take to my mother in the village. I don't see that Sorry, I had a network interruption. Apologies for that. I am not sure exactly at what point I lost you people. But I would like to start from this slide. That is slide 12 that is talking about balancing privacy and other rights. I don't know if I'm audible at this point. Can everybody hear me?
Yes, we can.
Okay, just a minute. Slide 12 of my presentation. As I was saying, balancing privacy and other rights. And the classic example I will give is national security versus privacy. Now, we have all related to a situation where you know that you have your right to privacy as an individual, but then there are situations maybe where because of national security, your right to privacy has been disregarded. At the same time, we know we need national security, but then the right to privacy is also very important. Now, when you try to define and appreciate national privacy vis-a-vis national security vis-a-vis privacy from a digital lens, how do we appreciate, how can the two exist in society in harmony? Can they coexist peacefully, national security and privacy? Because the right to privacy in the digital age refers to the protection of individuals' personal information, communication, and online activities from unlawful surveillance, data misuse, and unauthorized access, especially in a world where technology and the internet play central roles in our day-to-day lives. The classic example I will give you is post-COVID. We all know everybody had a take-home. And I don't think we are going back to that point where you physically have to walk from here to go to Golobi or to go to somewhere to send somebody money. Life has been made easy. Whether that is the advantages are greater than the disadvantages or vice versa, that's a story for another day. But how can we critically analyze the peaceful coexistence between national security and privacy in a community, in our space, in our lives? The two are important, but can they coexist? Which takes precedence over the other? We have all related to situations where your privacy has been disregarded, where national security has taken precedence. And how do we manage this? How do we go about this? That's a question that we all need to take home and appreciating it from the lens of the digital age. So in general, when you look at international and regional data protection laws, domestic laws, you look at the General Data Protection Regulations, that is the GDPR, you look at the African Union Convention on cybersecurity and the data protection, that is the Malabo Convention. When you look at the African Charter on Human Rights and People's Rights, when you look at the regional national data protection laws and regulations of countries that I've highlighted here, we have the protection of personal data, protection of personal information, that is, was that Somalia? No, I think this is Rwanda. Then South Africa, Data Protection Act, then the Kenya, then we have Nigeria. No, the first one is protection of personal information. The first one is Kenya, then the second one is South Africa, Data Protection Act. Then Nigeria has the data protection regulations. Then Ghana has personal data protection and privacy law. When you look at these laws, they all uphold the right to privacy. But then we have national security. And we can now relate to a situation where security organs, or in a matter of an emergency, something is done, and to some extent, you feel your right to privacy has been disregarded, and this matter that is done to maybe like to kind of protect the sanctity of national security, maybe of a certain situation or an event, you feel something is not right. So how do we reconcile it? So in reconciling the two, this is where domestic laws of respective countries, and especially maybe countries in Africa, this is where we come together to see how our laws that protect the right to privacy can sit and dialogue with the state. How do you dialogue with the state to see that they get to acknowledge the right to privacy of an individual, even in a situation that poses maybe some actions that may be defined as those that disregard data privacy. So, ladies and gentlemen, this presentation set out to appreciate privacy from an international level. It appreciated the right to privacy in our domestic laws, and how this privacy can still be upheld and preserved, even in those situations that are beyond our control in certain matters. So, ladies and gentlemen, thank you so much. I will now hand over to the moderator for the Q&A session. Thank you.
Thank you so much, Edna, for the presentation. I'm trying to go through the chat, and so far, I don't see any questions. But maybe in the interest of time, Edna, we could just continue and we'll keep monitoring to see if there are questions from our audience. Edna, you could proceed. Do we have any questions? Okay, I see one. Let me just quickly get that.
I think we can take that question and then we proceed with my presentation.
Yes, so the question is, are we supposed to cite those laws regarding data and privacy from Nigeria, Ghana, South Africa, among others? Maybe. Okay, then we have, when can a state's motives such as surveillance prevail over individual individual right to privacy. So Edna, maybe take the last question I just read out. When can a state's motive, such as surveillance, prevail over individual rights in the individual right to privacy? And then I will take up the former.
Okay, I do that. I take that right now.
Yes, please.
Okay, in under the laws of Uganda, state surveillance, that is, and of course, state surveillance usually takes place in the interest of national security, may take precedence definitely in a situation where maybe there's need for it. But the principle, and what I would like to advise to Helen Hamis is that surveillance usually happens when we know. When there's surveillance happening, usually you will know that this area is under surveillance, and there are usually notices, or like we are all aware that this place is under CCTV surveillance. Public spaces are under CCTV surveillance. And you will know that I'm in a place where I'm being surveilled, and these are private information about myself is going to be maybe processed or controlled or transferred maybe to third party or something like that. So I do believe, and I know under the laws of Uganda, surveillance will take precedence over the right to privacy one, where there's a disclaimer, there's a communication, there's prior communication, when there's consent, when there's notification, because for you to access such maybe public space that is under CCTV surveillance, you're aware that I'm entering a place where certain aspects about my personal life are going to be captured. But under the laws of Uganda, still we do have exceptions to the general rule, whereby surveillance will happen in like in a state of emergency. But clearly the state of emergency has to be proved beyond reasonable doubt. But unfortunately, in most situations, no explanations are given. You realize that surveillance may happen in certain private spheres of our lives, and no explanation is given to us. What you're told is this is a matter of national security, matters of importance that are beyond your control or your pay grade. So there are two issues: the law in a matter of national emergency, in the matter of a public good, like when somebody obtains a court order to obtain certain private details about somebody, and these are details that are usually handed over to court by an expert, like an expert in a certain field, are usually, like maybe if it's a medical records, they're supposed to be tendered into court by a medical practitioner. When it is maybe information about a child, it is a child maybe protection professional. When it's about maybe when it's about maybe like a professional person should be in position, should be the one to tender such evidence, like in court. When certain private aspects are like demanded for or called for using a court order, they are supposed to be tendered in by an expert opinion who has like some expert knowledge on that particular subject, not just anybody. But when you look at this question, it's exactly what we are looking at. Surveillance, like, kind of disregards the right to privacy. Under what situations is this allowable? There are provisions under the Data Protection and Privacy Act in the matter of a public good in a situation where a life is to be saved, and that is still has to be proved by an expert opinion from a medical practitioner, or in such situations of related nature. I think I've answered that question. Hello.
Thank you so much for your response. I got you.
Okay. Thank you, Edna. We had another question in regard to, are we supposed to cite those laws regarding data and privacy from Nigeria, Ghana, South Africa, and among others? This is how we are going to look at it. Pertaining to the hypothetical case that you will be addressing your minds on, and probably you should have started already. Obviously, the laws that are already in place in the East African region are key. They are primary to you able to build a case of your responses and submissions as either as applicant or respondent. But however, and those are the ones that ideally would be binding, given the jurisdiction. But if it was a case, that you would want to rely on, the case, it would be easier to rely on a case that you know has persuasive influence that would lend prejudice to either the submission you're making, or it will help to reinforce a particular legal issue that you're advancing, either way. But for this, we should restrict ourselves to the ones that that are in the region, the East African community. But obviously not also limiting yourselves to the regional and international legal framework, as already discussed by Madam Edna in her presentation. Those will come in very handy. But if also it was such a situation that there is an arrangement, if there was a case and the bilateral arrangements between these countries and any of the countries in East Africa, then that is when you would be able to cite them. For example, if it was a cross-border data protection issue, but then you have agreements between these countries, then you would rely on it to be able to advance any submission that you're making in terms of that case, in terms of the position that you would be developing, either it's a position paper or it's an advisory that you're making. Yes, but for the purposes of the hypothetical case, what would be most relevant would be the laws in the region, in the East African community. There is another question. Given the 20th century recognition of privacy in the UDHR, how can global legal frameworks be used to enforce cross-border data protection in today's digital era? Edna, would you like to give it a go?
Yes, let me give it a go. Yeah, in definitely Universal Declaration of Human Rights, we do factor it into consideration when we look at where we're at right now and the respective domestic laws. At some point, there's bound to be what can I say? Parallel. There's bound to be provisions that antagonize each other in one way or another. So this is something that happens and it is natural because the classic example is we have African states that were colonized by the British, whereas you also have others that were colonized by the French, and we all have different styles maybe of learning and so many other things. So remember, domestic laws originate from maybe culture, from so many things, culture being one of them. So in the event that in order to appreciate a certain, like maybe common law principle or a human right or something, a certain provision where domestic laws, where there are jurisdictional challenges for cross-border data transfer sharing, the best way to manage this is to have a regional arrangement or a framework that all states should agree on. And I think apparently right now as we speak, I think there's one that is going, there's one that is still under development in Africa. Last weekend, a colleague from the Personal Data Protection Office attended the NADPA, the National Data Protection Authorities engagement, a conference that was in Nigeria. And some of the things that are discussed in such spaces is how to harmonize, because you see at some point you're going to have to compete, even like in the regional markets, in the African market at a continental level, at a regional level. So how do you get to compete when you have competing, provisions under our domestic law? So the best way to handle this is to have like a regional arrangement or a regional framework that we all get to agree. It may not be like same word per word, but it should work in harmony with provisions that work in harmony, such that we should be able to speak one voice to encourage cross-border data transfer sharing, because we know I will want to study in Nigeria, I want to take a course, there's so much we have to share. The best way is to have a regional framework that we believe we should all participate in intentionally to come up with something that works for Africa as a continent. And that is currently still under development. That is how best I believe this issue can be addressed or managed.
Thank you, Edna. And just to add my voice, yes, yes, like Edna rightfully says, we could explore a regional data protection framework that would facilitate that. But we could also explore mutual recognition agreements, okay? That would help to facilitate lawful and accountable data flows. Capacity building and alignment amongst national regulators is also something that can be considered to ensure consistency.
Alternatively, the alternative, which I believe is more taxing, is under the Ugandan law, we do have cross-border data transfer policies, whereby there is a provision in the law that says that for you to share information across the border with another state, you need to have arrangements, memorandums of understanding, contracts that bind that state where you're sharing information to the principles, to the data protection principles that your domestic, your country stands for. The states where you're sharing this information needs to be able to appreciate and speak the same data protection language that you speak. Okay, not same word per word, but similar. They need to be able to respect personal data at the same level as you do. Because remember, you as an individual, you as a state, I shared my personal data with you and you assured me of privacy. So I do not know the third party. So if you're sharing my personal data with a third party, a different state, do they appreciate personal data and privacy at the same level like you do? Because for me to give you my personal data, I was convinced and assured that you do have privacy mechanisms in place to safeguard the integrity, the sanctity of my data. But the third party that you're sharing my personal data with, do they understand that language? So that's the question we need to answer.
Thank you, Edna. And just to also add that this is also still an issue out there. It's still a gray issue where debates and discourse is still being developed as to what can be done, especially when it comes to cross-border data sharing, and obviously vis-a-vis any issues that would arise. So the question also from a participant who was saying, how do the East African community partner states varying data protection laws as discussed in the bootcamp create jurisdictional challenges for cross-border data sharing, particularly in light of the East African Common Market Protocol's goal of seamless regional integration? Obviously, your question is valid, but this is an area that is where discussion is still ongoing. But ideally, like Edna has intimated, there should be thinking or reflections and appreciation for creating a common legal framework at a regional level. But then also, if that, while considering that, then countries can actually consider having mutual agreements that can facilitate cross-border data sharing and resolving of any issues that may arise concerning breaches and any other infringement. Edna, in the interest of time, you're welcome to continue with the next presentation so that we can catch up on what we have to cover today. Edna? As Edna prepares to come, for the rest of the participants, please send in your questions in the chat room. We are closely monitoring the chat room to ensure that we address all your questions or clarifications that need to be made. Edna, are you ready? Okay, as Edna seems to have gotten off, but maybe we can stream into the next, because while we wait for her to take us through module 4 as per
I'm
the
available.
program. Oh, you're back.
I'm
Okay.
around. I'm back.
Yes. Okay, good. Could you kindly proceed with the next presentation? Thank you.
Okay. Module 4, here we go. Module 4 today is going to look at on data protection and privacy. And right away, I know I'm looking at the national legal frameworks we have in Uganda. These are the domestic laws. We have the constitution, we have the data protection regulations, we have the regulation of Interception on Communications Act, the Computer Mis
We seem to have lost Edna. Edna, we've lost you.
Colleagues, once again, I had fallen off. My net connection is really interrupted today. I don't know why, but I will straight away go to my presentation. And I was on my 5th slide, that is legal frameworks on data protection and privacy. I took the liberty to highlight the national legal frameworks. These are the domestic laws in Uganda. Then I also looked at some regional legal frameworks. We do have the South African model law on data protection, the ECOWAS Supplementary Act on Personal Data Protection, West Africa, the Malabo Convention, and the GDPR, the General Data Protection Regulations. As you can see. So I will try to delve a little deep into each of these regulations. to appreciate how they get to uphold and help digest privacy from a digital lens. Definitely, of course, we also need to appreciate our domestic laws and on an international level. So the General Data Protection Regulations, this is a privacy framework that came into existence in 2018. And that was slightly before, in Uganda, before our law was enacted. And I think this is one of the frameworks that inspired other protection guidelines and frameworks, maybe across Africa and beyond, I believe in Europe. It governs the collection, processing, and protection of personal data for all European Union member states. And its core objectives include strengthening individual control over their personal data. We need to appreciate that this is something that we're not hearing for the first time. The frameworks that I discussed in the previous presentation all also clearly appreciate a person's control, the right to control their personal data and be in control of the privacy of their personal affairs. Then it also goes ahead to harmonize data protection laws. You know, the European Union, that engine has, when you look at that union, the member states definitely do have domestic laws that are customized maybe to a
Edna, we've lost you. As we wait for Edna to get back, are there any questions? Do we have any questions at this material time? Or a comment? Team members, do we have any questions or comments?
Members, apologies once again. I do not know what is wrong with my connection, but it's a general problem here. There is a general interruption. I don't know why. Apologies. Back to my presentation. So, members, apologies. I was talking about the regional frameworks, and I had started, I think, this slide, general data protection regulations, and I was talking about the core objectives, and I think I was talking about harmonization of data protection laws. This is something that is very important. Actually, this is one of the reasons as to why we are sitting here, to try and understand how we can meet each other halfway, create a nexus to try and harmonize the domestic laws of the respective regions and the respective states, to see that we ensure there is a responsible sharing of data, maybe across borders and beyond. So the GDPR has one of its objectives as ensuring that there's harmonization of data protection laws. How that is going to happen is still through dialoguing and coming up with frameworks that are owned by the audience, the intended audiences, the intended users, to see that they all get to create like a framework that all of them can abide by and follow, to see that there is a responsible sharing of personal data across borders for purposes of technology, learning, research, and beyond. So one of the other core principles includes accountability and transparency. The General Data Protection Regulations is very intentional on the principles of accountability and transparency when it comes to privacy and data protection. Accountability, it begins with you, the data collector, or somebody who is in the custody of personal data of maybe certain data subjects. Accountability for our actions, for the decisions we make and the actions we take, how we process personal data, and the repercussions of whatever we do, the decisions we take with the personal data. And then transparency. This is also another important principle. I would like to highlight that these are principles, I think, that do cut across like most of our spheres of life. And if you walk into most of our workspaces, the vision board, the mission, the core values, and the principles that drive our businesses, our workspaces, accountability and transparency is one of them. But we need to appreciate it from the lens of data protection and privacy. Now, transparency is very important because at some point, accountability is going to hold you down. And transparency being a principle in corporate governance, it calls for clear, transparent principles and policies in our operations when it comes to privacy of data protection, the privacy of the personal data that we collect and we need in our day-to-day lives, in our businesses, in order for us to make decisions and take actions. Transparency is defined as a clear, intentional way of doing something that is, I think, open to both the data collector and maybe the data subject. Are your procedures and policies that your data protection policies and procedures, are they transparent, and do they speak exactly that which actually takes place behind closed doors? So that is something we need to think about. So the general data protection regulations is very intentional on this. Then it also talks about lawfulness, fairness, and transparency. These are some of the principles that are highlighted in our domestic law, that is the Data Protection and Privacy Act of Uganda. With lawfulness, data and information, personal information, is supposed to be collected for lawful purpose, first and foremost. Then is it collected in a fair way? And transparency is not something I can emphasize enough. Then what is the purpose of collecting information? Is there a limitation to this purpose? What is the objective? Then we have a principle of data minimization. Do we just collect information for whom it may concern, or it's intentional information or intentional data? Because we know data is now the new oil, it is static, it has no boundaries. But what happens when it's obsolete? Accuracy. How does your data have integrity? Is it accurate data? Because we know data is not static. It changes. Today, I may be 42 kilos, and then maybe 2 weeks from today, I'll be 53. So data storage, limitation, storage limitation. Do we have limitation periods? What do our policies say? The integrity and confidentiality of personal data. These are the principles under the General Data Protection Regulations and Guidelines. So next we'll talk about, let's go to the African Union Convention on Cybersecurity and Personal Data Protection. This is the Malabo Convention. This framework was enacted in around 2014 by the African Union, and its main focus was around cybersecurity. I think this is around the time we were appreciating digitizing most of our economies across the African continent. It aimed at establishing norms and regulations around cybersecurity, electronic transactions, and personal data protection across African nations. So it talks about, so it focuses on cybersecurity, electronic transactions, and all those e-signature, e-regulations. So that is its main focus. And because we know that each state has a domestic law that definitely legalizes some of these maybe technological advancements, there is a need to harmonize these, because now we know that for a nation to really develop, you can't limit yourself to maybe only doing business within the confines of your state boundaries. We need to be able to compete in regional markets and beyond. But how do we compete? Definitely, we need platforms to, leverage against. We need platforms to be able to communicate, to be able to transact businesses and beyond. So the laws that legalize these platforms into existence need to be harmonized to speak similar parallel voices, to regulate the protection of personal data and promote confidence in electronic communications and transactions. And it has similar principles to the General Data Protection Regulations, such as lawfulness, purpose, limitation, minimization and accuracy, confidentiality, security. Then it also talks about cross-border transfer restrictions. And I know with cross-border transfer restrictions, respective states, I think, have provisions that I think customized to suit their situation. But then I would also like to believe that most of these cross-border transfer principles and policies and guidelines are all operate in harmony. That is why you see it is, I can make a transaction between Uganda and Africa, and rather between Uganda, Nigeria, Kenya, Rwanda, and beyond. So I believe cross-border transfer provisions is I think is a matter that needs to be discussed on its own to be in position to appreciate what each state does differently from the other, so that we are all able to appreciate each other's, unique ideas. So this presentation was shorter than the first one, and I would like to believe that we have appreciated at that level. And at this point, I hand over to the moderator for Q&A. Thank you.
Thank you, Edna. Do we have any questions? I've not seen any yet, apart from the original ones. Do we have any other questions? Do we have questions for this segment? Going once, going twice. Do we have any questions?
The chat room appears to be empty.
The chat room, yeah, apart from the old ones. Okay. As we wait for other questions, we will proceed with the next two modules quickly, because we are way out of time. Okay, Edna, if you could just turn off your screen sharing, then I can load the next presentation. Thank you.
Okay, thank you.
All right, thank you. Okay, so the next, okay, are we able to see the screen, all of us? Can I have a show of hands? Okay. I just want to start the Okay, do we see the screen? Okay.
Yes, we
So-
see.
Okay, thank you. So the next two modules are going to be handled as 2-in-1, and basically it's the module on privacy in the digital age. And then we will also handle privacy mooting. Okay. So basically, with the two modules, we want to explore the challenges of privacy in the digital era, including privacy, data monetization, and protection strategies. And in the first module, which is on privacy in the digital age, we'll cover surveillance, big tech role, social media risks, cybersecurity, and encryption. And I just want to kick off with the quote from Covas, that privacy is not an option, and it shouldn't be the price we accept for just getting onto the internet. Obviously, with Covas' quote, we realize that the non-negotiable nature of privacy is amplified and setting the stage for its critical role in the digital age. So in terms of privacy in the digital age, we will look at government surveillance and mass data collection, big tech and data monetization, social media and privacy risks, cybersecurity, cybersecurity best practices, and the role of encryption in privacy. So in terms of government surveillance and mass data collection, it involves systematic monitoring of citizens' communications, generally, and activities, often justified as national security, which my colleague Edna has, throughout her presentation, intimated to, and even in the earlier presentation, I did talk about it. But obviously, as national security is being justified, we have concerns about privacy being also raised. Mass data collection aggregates, the mass data protection aggregates vast data sets that enable profiling and tracking. With this, the key issues, for example, are with programs like PRISM that collect emails, calls, metadata globally. Obviously, most of the times this is done without consent. In the US, for example, Section 702 of the Fisher Amendments Act permits targeting non-citizens outside the US, but captures citizens' data incidentally. So the data is actually captured without consent. And obviously the impact with such situations that are not only only in the setting of the US, but even our own jurisdictions, is the surveillance choose, the fact that the surveillance choose free speech and dissent as individuals self-censor themselves to avoid scrutiny. And we have the Office of the High Commission for Human Rights in 2023 warning or giving warnings on pervasive surveillance and the prospects of undermining vibrant societies. In the East African community, we have, for example, in Kenya, the data protection Act regulates government data use, but programs like the National Integrated Identity Management System raises concerns about unchecked surveillance. And this is not only to Kenya alone, but even in other jurisdictions. Uganda is not an exception, Tanzania is not an exception, and the rest. While scrutiny is vital, but where we have blanket data collection, often there is lack of transparency and proportionality, which conflicts with what? The privacy rights. So targeted surveillance with judicial oversight would be one way in which to bring about this balance. Edward says in this regard that urging that we don't have to care about the right to privacy because you have nothing to hide is no different than saying you don't care about free speech because you have nothing to say. That is something to think about. Obviously, the challenges at the end of the day with such a narrative is that the surveillance is harmless for the innocent, emphasizing privacy. The fact that privacy is universal and it is critical for all of us. Talking about the big tech and data monetization, companies like, for example, Google, Meta, and others collect and monetize personal data through targeted advertising and data sharing practices, which, as we've already heard in the plenary, in the Q&A, raises ethical and privacy concerns. Some of the key issues arising out of these are for example, the globally digital and the revenue that is reached. For example, in 2023, as a result of that targeted advertising, 626 billion was attained in 2023. And as a result of that personal data, driven in terms of browsing history, location, preferences, and the like. In East Africa, the platforms like Safaricom in Kenya, for example, leverage customer data for targeted mobile money ads. So social media and apps use trackers. We've seen, I'm pretty sure every one of us on the call has interfaced with cookies, beacons, and others to profile users, often without explicit consent. And for those, I don't know if there are any of you who have interfaced with our scorecard, but our scorecard, we take stock of the compliancy of companies in terms of data protectors and data processors. We evaluate and examine their privacy practices. And as part of the things that we use, because we use publicly available information, one of the things that we look at are the security, the security aspects or provisions that are in place to secure the data that is collected. And as such, we also we examine in the apps of the different companies that may exist already on their websites. We will look at aspects like the trackers. So, like I've said, so personal data is likely to be collected without explicit consent, and obviously the more the trackers, the more the data that is are collected. And then obviously this data, when it is collected, usually it will be sold, shared with third parties. obviously enabling discriminatory practices like predatory lending, okay? In the East African context, for example, Kenya's e-commerce market, Jumia, but obviously not only Kenya, we have Jumia in Uganda and in other states. We have these platforms using data for recommendations, and of which it has contributed to 317 billion US dollars in Africa. In Africa-wide, and the e-commerce revenue from the e-commerce revenue in 2024. However, the laxity in the regulations obviously put risks to the data and obviously would encourage data exploitation. Zooming in to the situation with the big techs, their surveillance capitalism commodifies users. So at the end of the day, users, the data subjects are used and are portrayed as commodities. Obviously, for them as big techs, prioritizing profit over autonomy. So obviously, with our current legal frameworks that are not adequate, that are permeated with gaps and with weak enforcement, this heightens the vulnerabilities, especially in developing economies. And we are not an exception as East African community members. So we need to make sure that the culture of monetizing our personal data at every twist and turn is countered with protection of people's personal data. This was this was the case and quoted in the congregational testimony in 2019 in the US, which obviously amplifies the need to challenge unchecked data monetization and obviously advocating for stronger protections. Social media and privacy risks. And we've seen that social media platforms amplify connectivity, but whereas they bring about this networking that we all enjoy, and the connectivity, the more connectedness that we experience, it also poses significant privacy risks, obviously through the data that is collected on these different platforms, the data that is shared, and obviously most of them have inadequate security for this data. The issues surrounding social media platforms are in terms of the exposure of this data. Platforms like Facebook collect data on posts, likes, and connections, often sharing with third parties. For example, in 2019, Flow, a period tracking app, settled with the FTC for sharing health data with Google and Meta. Obviously, the vulnerabilities with such platforms are in the form of weak encryption. For example, only 5 of 50 Muslim prayer apps encrypt data. So with these weak encryption, with these encryption mechanisms in place, these enable breaches, as seen with the Muslim apps that I'm talking about, that sell location data to the US military contractors, for example. In the East African context, in Tanzania, influencer marketing relies on user data, with ads spending with spending projected at $206.5 million US continental wide, and this is as of 2025 this year. Obviously, with this kind of state of affairs, it is permeated with limited user awareness, which obviously increases risks of exploitation. Social media's networked nature, for example, tagging friends, and all other activities that undertake during these social media platforms exposes other people's data and violating communication privacy. Users are often unaware of the risks due to the opaque policies that embed these platforms. Lee and Turner say that the online surveillance of religious minorities demonstrates just how widespread abuse of personal and interest-specific data is. And this, if you look at it more closely, highlights the systemic nature of privacy violations on social platforms, especially for marginalized groups. Let's talk cybersecurity best practices. Obviously, these mitigate privacy risks by securing data against breaches and phishing. What are the practices? Strong passwords, use of complex, unique passwords with a manager, like LastPass, two-factor authentication, which adds a second verification step, reducing unauthorized access, software updates, which help to patch up vulnerabilities to prevent exploitations, phishing awareness, which avoids clicking suspicious links, a common social engineering tactic. In the East African context, taking a look into Kenya's ODPC, the Office of the Data Protection Commission, it recommends a two-factor authentication for mobile banking apps to counter rising phishing scams. But this is also something that Uganda has also encouraged. Cybersecurity empowers users, but shifts responsibility to individuals, highlighting the need for corporate and regulatory accountability. IEEE Digital Privacy in 2024 has highlighted that cybersecurity is not just about technology, it's about behavior and awareness. So this obviously critically puts the human being into the heart of cybersecurity and urging proactive user education. The role of encryption in privacy. Encryption secures data by encoding it, ensuring only authorized parties can access it, critical for communication and information privacy. End-to-end encryption used by apps like Signal, even WhatsApp has, ensuring only sender and recipients can read messages. Disk encryption protects stored data, for example, BitLocker for laptops. In the East African context, we have, for example, Rwanda's data protection law that mandates encryption for sensitive data, and enhancing, obviously, trust in digital services. The challenges are with governments, for example, in the case of US versus Apple in 2016, that argued that encryption hinders security investigation, while tech firms prioritize user privacy. Encryption is a double-edged sword in this case, and in light of all this, vital for privacy, but potentially shielding illicit activity, requiring balanced regulation. So all these are things that we need to reflect on in how a balance can be attained from national security and the right to privacy to aspects like this. So encryption provides a technological solution for securing communications. But obviously, as we very well know that technology keeps evolving, even they have been of late, we are alive to the fact that there's possibility of encryption being broken in the form of spyware technologies. Despite the fact that encryption is a practical tool for privacy protection. With that, we come to the end of Module 5, and I would like to continue with Module 6 on mooting and privacy advocacy. But before I get into that, do we have any questions?
I have something to supplement.
Is this Edna? Okay.
Yes, this is Edna.
Yes.
In your slides, you talk about some of the tips, security tips that you advise people to embrace. I believe the most important and one of the best, actually the priority tip that all of us should have before you talk about the two-factor authentication, strong password, and all that. We all need to appreciate and acknowledge the fact that we are targets to cybercrime. Because once you acknowledge that, you'll be more intentional. But you see, the usual, definitely everybody has a password, two-factor authentication, because it's a system that was adopted by your office practice. But you intentionally, at an individual level, if you get to appreciate that you're a target of cybercrime, it is going to go beyond what you're required to do at the workspace, because when they are giving you a gadget, it comes with terms and conditions, and you have to maybe change your password every maybe 3 months. You have to have two-factor, you have to have active, software and hardware, maybe, antivirus, things like that. Thank you.
Thank you, Edna, for that. I saw a question. How can meaningful user consent be ensured in big text data collection and monetization practices? Obviously, with these, it is to make sure that we question the privacy policies of these big tech companies. The privacy policies, we need to question what these policies or notices that they have, what do they have in place in terms of securing personal data that is accessed by their technology that they are using. And with this, I want to also lean myself to the privacy scorecard that we do issue annually to borrow that experience that we usually conduct. Like I said earlier on, we look at the privacy practices of these companies, and there are certain, we use certain indicators. So there are certain things that you will have to look at and be able to question. So obviously, there's a need for you and I as data subjects to be proactive, to be aware. We need to be aware of the data collectors or data processors, that all the people that we give our information to. We need to be aware of their dealings. And one of the simplest things, for example, would be whether they have privacy policies in place. We have some of big companies that are not do not even have privacy policies in place. And if there are privacy policies in place, what do they provide in terms of ensuring promotion of the rights of data subjects, but also how are they making sure that they are compliant with the data protection laws in their jurisdictions where they are operating? What are the things that they are putting in place, for example, in terms of protection of or security of the data that they access? And if they collect this data, what do they use it for? And what amounts of these data what amounts are being collected? Is it the required data, or they're even accessing and collecting beyond, over and above what they need? And if they do that, what are the storage mechanisms and protection of this data? What are the mechanisms that are in place? So it is these things, apart from them being required to be compliant with the law of the day, but also as data subjects, we need to be proactive about ensuring our rights by making sure that you're critical about the companies that you deal with, especially with these online transactions and all that. So before you transact, you need to be critical. Why is, for example, some of the personal data being requested for? Is it really, needed? Yeah? What purpose will it be? What will it serve? That kind of a thing. With this, I wish to move on to the next module. I don't see any other question. And the next module is mooting and privacy advocacy. We will run through this quickly because we are way out of time. Under this, I would want us to look at why privacy law matters in mooting. Privacy law matters because it is central to mooting due to its relevancy in real-world legal disputes, testing advocates' ability to balance individual rights and society interests. Privacy cases, for example, apart from the law, privacy cases address cut-edging issues. For example, surveillance, data breaches, and others, making them ideal for mooting. Also, complexities require navigating constitutional, statutory, and international law. For example, the GDPR, as already discussed by Edna, but also we have our data protection laws in our respective jurisdictions in Kenya, Tanzania, in Rwanda. And if we are to zoom in some of these data protection laws, for example, in Kenya, we have enforcement. I did talk about fines. I did share, there was a slide I shared some of the fines, administrative fines that are there. And I want to make reference to it without me repeating myself. And then also to critically wrap up this is that privacy law in mooting challenges advocates to question the state and corporate overreach while defending fundamental rights. But also mooting is an opportunity to research on areas that seem to be gray. Usually as mooting or moot courts help to contribute to the discourse that is ongoing of issues that are seemingly either there are no solutions for them. We are still experiencing gray areas, and these can and the research that you make can ably contribute to potential strategies and reforms that can be undertaken. I want to share a quote by Gestrin, who says privacy law matters because it defines the boundaries of freedom in the digital age. Obviously, with Gestrin, we see that the privacy law frames it frames privacy law as privacy law is being framed as a cornerstone of modern legal advocacy and critical for moots. So mooting helps to frame privacy law. Building strong legal arguments around privacy violations. Obviously, this borders effective privacy arguments in mooting, combining legal reasoning, evidence, and ethical considerations. And in building strong legal arguments, you have to identify the violation, pinpoint the privacy type, informational communication, is it a legal breach? And then obviously you will rely on the law, both at national and regional. Then you can cite precedents that in form of cases. For example, in the West, we have Carpenter versus United States for warrantless data collection. That's what the case was on. And then there's need to balance interests, obviously weighing individual rights against state or corporate interests. And this takes us back to the issue Edna in her presentation intimated, and in even previous presentations, the issue of national security versus privacy. In the East African context, we urge violations under, for example, the Rwanda Data Protection Act that addresses itself on excessive data collection. So strong arguments expose power imbalances, challenging narratives that prioritize security over rights. From Klein, he says, a good advocate uses the law to tell a story of justice. Obviously, this emphasizes narrative in legal arguments, which is key to persuasive mooting. Notable privacy-related moot cases and precedents. Obviously, these, once you get hold of them, they provide frameworks for mooting privacy issues, offering legal precedents and arguments, and they help to substantiate your submissions, and as well as the memorials that you prepare, which you definitely make oral submissions during that phase of the competition. I want to share some of the cases from the US to even our own region. So in the US, we looked at the Carpenter Carpenter versus United States, where the Supreme Court ruled voluntary cell phone location data collection as one that violated the Fourth Amendment amendment protecting informational privacy. And obviously, if you ever get a situation where you're in a moot and this comes up, you would argue for warrants in mass data collection scenarios. The way you would, I'm relating it to a criminal, or not even a criminal, but in the event of any arrest, you would, any arrest to be effected has to be against a warrant that has to be produced legally. Then we have another case from the EU region, Shrimps versus Data Protection Commissioner, where the EU court invalidated the EU-US data transfer agreements due to US surveillance. And obviously this helped to strengthen the GDPR that was being relied on in this case. So remember, we've been having in the Q&A and in the latter discussions, we've had questions and discussions around cross-border data transfers to sharing, and this is a challenge, obviously, for us as a region in the East African context. But in terms of cases, related cases in the East African context, we have ODPC versus opposition, Kenya in 2023. It's a 2023 case where Kenya's ODPC fined the opposition 2,975,000 Kenya shillings for using third-party contact data without consent. Obviously, this helped to reinforce the Data Protection Act of Kenya in Section 25. So in a setting of a moot, you would argue for stricter consent requirements. And we have ODPC versus WorldCoin. This is a recent case. WorldCoin collected iris data from 3,000 plus Kenyans using crypto insensitives. And this was challenged by the Data Protection Office for obviously being undertaken with lack of informed consent. The High Court in this case ordered data deletion within 7 days, which ruling is ruling the incentives negated consent, reinforcing obviously again the Data Protection Act's transparency requirements as part of the principles that we've talked about in the previous presentations. In terms of for our purposes for the Moot and for Moot Court, the debate would be if incentivized data collection undermines consent, and we would also use the Shrimps versus DPC case for cross-border data arguments. Obviously, this is a landmark case, especially when it comes to digital sovereignty, which showcased Kenya's robust privacy enforcement. We also have Nubian Rights Forum and others versus Attorney General in the Hudma number case of 2020. Kenya's Hudma number biometric data ID system faced challenges for lacking data protection safeguards, and obviously, which risked privacy. violations. The High Court in this case halted rolling out until a regulatory framework and a data protection impact assessment were implemented, citing breaches of Article 31 of the Data Protection Act. In terms of Moot setting, you would urge for mass biometric data collection without, you would argue if mass biometric data collection without data protection impact assessments would violate constitutional rights. So where we have mass biometric data being collected without data protection impact assessments being undertaken, this would amount to violation of constitutional rights. And we would, in that case, as a Moot, you would advocate for mandatory data protection impact assessments being undertaken because they are provided in most of our data protection laws. So with this case, it affirmed the right to privacy as a constitutional right that even that predates the Data Protection Act. Remember that most of our data protection laws are still new, but we've had the right to privacy being provided for previously in other legal frameworks in our jurisdictions, from the Constitution and to the fact that we are state parties to the key international human rights instruments of which we have signed and ratified, and as such, they put an obligation on our national governments to domesticate. We have also the case of ODPC versus Nova, Pioneer Kenya, where Nova Pioneer shared a minor's data with third parties without the parental consent. And obviously this violated Section 25 and Article 31 of the Data Protection Act and regulations. ODPC fined Nova Pioneer 500,000 Kenyan shillings, an equivalent of 5,000 USDs. And this is also a recent case, which with this ruling, it emphasized that consent of minors it emphasized that there should be consent for minors for data that relates to minors, and it is sensitive data. So for purposes of our Moot setting that we are in right now, you'd urge for organizational liability for unconsented data sharing, which would, and you would rely on the data, your respective data protection acts. And in this case, for Kenya's case, it is Section 63. But as I cite some of these sections, think of what is in your own jurisdiction. So obviously this case, which only happened this year, sets precedent for minors' data protections in educational settings. These cases together that I have shared underscore the proactive privacy enforcement, offering you as Mooters opportunities to challenge state and corporate overreach while advocating for constitutional and statutory protections. From the High Court of Kenya in the Nubian case, privacy, the High Court of Kenya said, privacy is the bedrock of individual dignity and autonomy. So this, as Mooters, should inspire you to defend privacy as a fundamental right, grounding arguments in jurisprudence. These cases reveal tensions between global standards and local enforcement, critical for crafting nuanced Moot arguments. I want to quote Gestrin again, who says precedents are the building blocks of justice, guiding us through the digital frontier. So obviously with his quote, he highlights the role of case law in navigating evolving privacy challenges. As we close, I just want to say that our two modules on privacy in the digital era and privacy in mooting puts privacy faces threats from government surveillance, big tech monetization, and social media risks, countered by cybersecurity and encryption. Mooting privacy law hands advocacy skills, using precedents and arguments to challenge violations and protect rights. So obviously, in terms of advocacy for your purpose, use mooting to shape privacy law, address local and global challenges. That is what I intimated too much earlier, that mooting helps you to contribute to the discourse of any issues that are coming up that pose gray areas or where there are no solutions. And the moots help us to, with the research that we undertake, help us to make those contributions to those discussions that eventually form reforms. With this, I want to end with OHCHR's quote that the future of privacy depends on our ability to advocate for it today. So I hope that modules 5 and 6 inspire you to proactively advocate, both in your, as you prepare your memorials, and as you think around how best to address the legal issues in the hypothetical case. With this, I want to thank you for your attention. Do we have any questions? I think there is one. Considering just how much content we've had to cover, is it possible for the slides on the same to be shared? Yes, we will share the slides at the end of the boot camps. So don't worry. But this does not mean that you shouldn't pay attention and make initial notes as the discussions are going on, because there are things that we are busy obviously sharing that may not necessarily pitch on the slides. But yes, you're sure we will share the slides. Any other questions? Do we have any questions? Okay.
I have a question.
Yes.
Yeah, so I'd like to know, during the time of the submission as a mooter or the oral pleading, is it possible, because I saw the first the other presenter who was before you talks about the Malabo Convention. Now, because we
Yes.
all know that the Malabo Protocol is not yet active or is not yet working, but is it possible that we use the Malabo Convention on data and privacy in order to convince, to put in our arguments? Is it relevant we use the Malabo Convention in order to back our arguments? Or since it's not into use, can we just leave it and focus on the one that is currently into use?
No, you should use it in as far as that it has the ability to advance. In as far as it has the ability to advance your argument, your point that you're trying to put forward. I don't know what.
Yes, so
But it is a legal framework that is there and we should be able to utilize it. I
okay,
can't give beyond, I can't submit beyond that, but it should be to the extent that it does help you to make your argument strong. Yes,
okay. Yeah,
Chimoli.
again, I just wanted to just add
Yes.
before yeah, thank you. So yes, so because I understand that the Malabo Convention, or the Malabo Protocol is not currently into force, but since it is actually relevant and it is needed, yeah, it is actually relevant and it's needed to build a strong arguments, we can use it and other data laws that is being used under the African Union and internationally. Thank you.
Okay.
Thank you for the opportunity. This is Chimoli. And
Yes, Chimoli.
I'm quite confused when it comes to the laws to use following the hierarchy. It being that these are East African countries and particularly we are from Uganda. So when we are relying on the constitution, should we cite the one of Uganda? Because when I look at the hypothetical case, the name of the country suggests a little bit Kenya. So would it be okay if I rely on the Ugandan constitution when making submissions, or I should consider the one of Kenya? Thank you.
Unfortunately, Chimoli, you're asking a leading question, and I am not going to help you answer that. But from the hypothetical case, you can see that it is domiciled in the East African region. So you have the prerogative to make use of the available laws and regional and international instruments available to prepare accordingly your memorials, and even in terms of building your arguments. You have the prerogative to use what is available within the region. As to what you would best suit you, I cannot decide that for you. That is something that you have to decide on your own, because it's part of you making sure that you interpret the hypothetical case correctly.
Much obliged.
Yes. Do we have any more questions?
Yes, madam, I'm so sorry. Is it a way that you can reiterate in summary? Like if I get the question was whether we can use the domestic laws of other countries in East Africa. Can you reiterate the answer back, please?
I said that if you look at the hypothetical case, it is domiciled within the East African region. So you are at liberty to use the available national laws, regional, international, as to the extent that they are appropriate and they would help to put your arguments out there, but also in building your arguments, relying on them as instruments that can articulate whether you want to articulate the violation, whether you want to use a case to add to strengthen your submission and your persuasion. You're welcome to use them. But as to what you should use, surely I should not be the one to tell you that. That is within. It is part of you. It is part of your interpretation of the hypothetical case, and making sure that you do understand. Any questions? Any more questions? We are way out we are beyond the time. Do we have any more questions? Okay, if there are not any questions and we are already past really time, we are 45 minutes late. I want to thank you so much for those who have braved and stayed onto the call and participated in this bootcamp. Please, I urge you to turn up tomorrow, and because first of all, your participation is mandatory, but also if let us keep time. Let us keep time so that we can start on time. The formalities have been dealt with today, and ideally tomorrow we will just simply delve into the modules. So with this, I want to wish you a nice evening and stay safe. See you tomorrow. Bye-bye for now.
Thank you.
You're welcome.